me like you do, and hold 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 me
Good morning, good morning, good morning. Hi, everyone. It's Thursday. The weekend is almost here. Woohoo! All right, you guys, let me say hi. Good morning, Mrs. Troy. Good morning, Harley Quinn. Good to see you. Rope Scout. Good morning. Good morning, Tony. Good to see you. How is everyone this morning? Good, well, I hope everybody's doing well. I want to see, make sure I didn't miss anybody. Nope, I did not. Good morning. So, let me answer Rope Scout here, who says, "Hello, friends. Okay, I have a question about this trial. I watched the first one and wasn't sure of his guilt. Bindi, what's your thought? I haven't watched this one because of work. Just curious." Okay. Hey, Sarah Bellum. Good morning. Let me put that back on here. Sorry, I meant to do that. I didn't mean to do that. There we go. Okay. Lordy, not all the way awake, apparently. So, Rope Scout, to answer your question and be ready, it's about to be a Miss America one. Break show sales. All right. When I watched and covered the original trial, I covered the original trial late. Like the verdict had already been rendered and the appeals had already been started. I know his trial was in September of 2019. I did not have a channel then. I believe I covered it in 2021. It was I have the playlist included in the description. And Teresa from Criminality is the one that was like, "Hey, let's do this trial." And I was like, "Okay, cool." So we did. Now, when I watched the original trial, I was not convinced of his guilt. But at the same time, I am not currently convinced that he has an actual innocence claim. Okay. For me, those are two very different things. So during a trial, right? We all know this. It is the state's burden to provide proof beyond a reasonable doubt. For me, there were a couple of things that opened the door to reasonable doubt. One was the size of the hog barn and the limited amount of time that Todd Mullis would have had to have this confrontation and then attack Amy with the corn rake and then get back to the hog barn where his son was also working. And when his son testified that the only time that Todd Mullis was out of his sight was when he went in that little office to get a drink of water a couple of times, 2-3 minutes tops. That seems incredibly short. That was number one. And the other thing that gave me reasonable doubt was that when the medical examiner testified, I never could understand the injuries and how the state thought that they occurred. And I'm not saying like with I think everybody agrees that the corn rake is what caused those injuries. It's just that, like, the order in which they occurred, and there was never a clear explanation of if he attacked her with this corn rake, why there were 6 holes in her body, but only, 4 holes in the in her coat, and it just the testimony was very unclear, and so for me, if I'd have been sitting on that jury, I would have had reasonable doubt. So, at this point in this is a PCR, bench trial, which means, it is a post-conviction relief trial. So there is only the judges hearing this evidence, and the, appeal that they're trying to raise is a ineffective assistance of counsel, which is an incredibly difficult and very rarely successful appeal. Um, I'll give you, I gave one example, Brendan Dassey. I'll give you another example. J Currently, Judge Dan Stidham in Arkansas. He was Jesse Miss Kelly Jr.'s, original trial attorney. By Arkansas criminal rule of procedures, Dan Stidham wasn't actually qualified to represent Jesse Miss Kelly Jr. in his trial. He didn't have enough, trial experience, and particularly, he didn't have, any experience in a first-degree murder case. So, by Arkansas's own rules, he was not eligible to, um, represent Jesse Miss Kelly Jr. in his original trial, and he testified, for Jesse's appellate attorneys at, um in Arkansas, it's called Rule 37, but it's an ineffective assistance of counsel appeal, and it was denied. So, that's what's going on right now. Now, the defense maintains at this point in the appeals process, it was different in the original trial. In the original trial, the defense said, yeah, it was murder, but Todd didn't do it, which the defense now says that's not what Todd didn't want. That defense. Todd wanted them to present evidence of an accident because that is what Todd believes happened. He doesn't believe it was murder. He believes it is a horrible accident. Okay. And the defense says not only is there clear evidence of, um, ineffective assistance of counsel, but Todd Mullis has an actual innocence claim, which means he did he had nothing to do with what happened to Amy at all. I am not there yet. There's a huge difference and a huge um, I need more proof, for me to, get to actual innocence. And I kind of he did, Tony. Tony says, it's funny about Dan Stidham. I felt like he really cared about Jesse. He did. He did really care about Jesse. When Dan first got the case, you know what he thought he was going to be doing? Trying to get a plea deal. He didn't think that he thought that potentially Jesse was guilty, and that the best chance and hope he had was trying to get his client a plea deal until he started talking to his client and ask because at that point there were 2 confessions. It's not. I mean, I guess it's I'm just gonna say 2 because that's the easiest thing to say. There was 1 confession that was not recorded. The prosecutors went to a judge to get arrest warrants based on that initial confession for Jason Baldwin and Damian Eccles, and they were told no. That's why there's that second quote unquote clarification statement, because the judge said, there's some problems here. So anyway, once he started really getting into the case, he actually started to realize that there was a strong potential that Jesse was innocent of this crime, and that it was a false confession, and it was a lot. So anyway, for me personally, there's a high burden of proof that I require before I feel like somebody is actually innocent. And in my own defense of that, because I know there are people that feel very strongly that Todd Mullis is actually innocent, but they have done research into the case that I have not. I have tried to continue with this bench trial much in the same way that I had with the original trial, and only base my opinions on what's presented in court. And so, so far, with this bench trial, I have some serious reservations, particularly about the forensic pathologist who performed Amy Mullis's autopsy. I think that that she was perfectly competent. That's not the issue. I just think that she was an inexperienced forensic pathologist at the time she performed Amy Mullis's autopsy, and I think that this is a incredibly complex and unusual case, and I think it required somebody with um, a little bit more um, experience. So, Henry. Oh, well, don't just wait, Henry, because Allie and I have some stuff, so you might not be all like pea shit out. Ah, there might be you might find some new quotes to quote. So yeah, that's how I feel about it. At this point. Yeah, and don't smoke too much. And Tony, yeah, I remember that. Okay, all right. So this morning, what we're gonna do, and I also like to apologize. I was supposed to go live last night and do this 2 hour um, testimony, and then we were going to start today with day 3. But when the granddaughter requests your presence, bruh, you got to go. It is what it is. So I appreciate you guys understanding and being here this morning. By the way, if you haven't done so already, give me a favor, give your girl a thumbs up, pretty please, or a thumbs down, whichever. But anyhow, so we're going to listen to. I've got some stuff I have to do today. So what we're going to do is we're going to listen to this biomechanics testimony from Dr. Valentina, and I cannot remember how to pronounce her last name, so I will wait until I hear her say it, and then I'll say it, because I don't want to mess it up. I know how that feels. So, yes, our little Esquire comes first. That's right, Tony. Alice, stop clawing my rug, lady. Anywho, so it'll be a quickie day today. And then tomorrow we'll pick up, which is Friday, we'll pick up with day 3 and go through all of that. And I can also stream on the weekends. I will say that, like I said, Allie and I are waiting on some Letitia stuff. And should that come through, of course, we will take a pause in Todd Mullis. And then we will resume after we are done with the Letitia stuff. Another thing I want to talk about, for those of you who have been following Donna Adelson's case, the judge issued his order on whether or not Mrs. Adelson was eligible for bail, and it was denied, due in large part to number one, basically everything the state said about the money, the paying, all those things, and they have to view the evidence in the favor in the light of which is most. Wait, how does it go? Okay, they view the evidence in the light most favorable to the state. There we go, Jen. But the other part of it was this trip to Vietnam. She had tried to get an expedited visa to Vietnam. She had a one-way ticket to Vietnam, and she began trying to get this expedited visa the day after Charlie Adelson was found guilty. I mean, look, Donna can sit up there on that witness stand and say whatever she wants. Okay. But the rest of the world, using common sense, understands that that lady had intent to flee. She was trying to flee. And I understand her lawyers doing their part and doing their job, but let's be serious here for a minute. The only reason she didn't flee is because she was stopped. Okay. Had she hung up that call properly and that part not been recorded, Donna Adelson would be in Vietnam as we speak. Period. The end. Not a doubt in my mind. They intended to flee. That's it. That's all. So, without further ado, let's get started on the part, the rest of day 2. Oh, before I forget, one last thing, and I promise then we'll start. That's why I started a little early, because I knew I had some stuff I wanted to talk to you guys about. I am finally going to do the documentary on Kai, the hatchet wielding hitchhiker, and I have the case files and the evidence from his first degree murder trial and the murder of Joseph Galfney. Galfney, yes, Galfy. And so I'm going to work on that at night when I'm not streaming during the day. But I want you to know, I cannot do a documentary and censor it enough for it to be YouTube friendly. I just can't. I feel like I would be doing a disservice to the victim if I did that. So this documentary will be available for Patreon only. I'll put my Patreon link in the chat. I only have one tier. It's $5 a month, and you can ask the other Patreon members. I'm getting better about doing Patreon. The other thing I want to do in Patreon is talk about the Gabby Petito documentary that came out on Netflix. And so that'll be over there as well. And I plan to be far more active in the Patreon. Okay. I apologize for being a little lax. Moving to Texas, it gets, when you move and your situation changes, your schedule changes and stuff, the older you get, the harder it is to recover. And so I'm getting back. Okay. I'm working on it. And I appreciate everybody's support and patience. Truly, I do. All right. Good morning to Violet, just coming in. Patricia, good morning to you. And Rachel Lee, good morning. Who else have I missed? Neat Noodle, good morning. Good morning, Henry. And I got to say, Neat, I so appreciate you always showing up. I appreciate you as a mod showing up all the time. I really do appreciate that. And call me Sadie. Good morning. All right. Hey, Nature Rocks. Good to see you. All right. Now, good morning, Nitka Ditka. All right, you guys, do we feel that we are ready? And Violet, I think I missed Violet. And no, Violet, you are not. Violet says, am I the only one who thinks Wendy is next? You're not. And I'll tell you why I think Wendy is next. Yes, she testified at Charlie Adelson's trial, right? But she had limited use immunity. That is not total immunity. And there are all kinds of ways that she could be next. Oh, before I forget, one of the last things that was filed when I just looked at the docket for Wendy Adelson's case is a request for transfer. Guess for who? Catherine McBenoit. So there you go. And there's 2 requests for transfer. So I think the other, I think Sigfredo Garcia also has one. I need to go back and check that for double sure. But that's what's going on. All right. Now, without further ado, for real, all new business, old business is done. Let's start this hearing up. All right, here we go.
Phone on in front of you there once you're seated.
Well, let me fix this.
Yes, I am
Right.
Valentina.
Can you introduce yourself to the court?
Yes, I am Valentina Ngai.
Ngai, Dr. Ngai.
Entinangai.
Dr. Ngai, were you retained by Mr. Mullis' counsel to provide opinions in this case?
No, the firm I work for was retained and I was assigned to the case.
Thank you, and we'll get into that in a minute. Can you tell the court what your profession is?
Yes, I am a biomechanical engineer.
In brief terms, what is a biomedical and biomechanical engineer?
So biomedical is the overarching heading that it's called, and essentially it is the application of scientific and engineering principles to biological systems to solve problems. And biomechanical engineering is a subset under biomedical engineering that specifically studies the response of biological tissues to applied forces and motions.
Do you hold any degrees in the field of biomedical or biomechanical engineering?
Yes, well, I have 3 engineering degrees.
What are those degrees?
I have an undergraduate in civil engineering. I have a master's in mechanical engineering, specializing in biomechanics, one of my specialties. And I have a PhD in biomedical engineering. Again, one of my specialties is biomechanical.
You're not a medical doctor, Dr. Ngai.
That is correct. I am not a medical doctor.
How is biomedical engineering different from being a medical doctor?
Medical doctors are trained to diagnose and treat injuries. That is not what I do. I do not diagnose and treat. My job as an engineer is to consider the forces and motions and how the body responds to those forces and motions.
You mentioned it was your company that was retained by Mr. Mullis' counsel. Where is it that you currently work?
I work for Robson Forensic.
And what kind of company is that?
It's a consulting firm that employs multidisciplinary expertise, and we basically run investigations.
How is biomedical or biomechanical engineering used in the field of forensics?
Before she answers that, I'd like to just take a tiny moment really quickly for some fair use commentary. You know, it occurs to me, and I think about this quite frequently during trials when the defense has hired experts. There are many people who hold the opinion that these experts are essentially hired because they gave the opinion that, like, you can pay for their opinion, which you can, but you can't sway their opinion. You see, the thing about being, for example, Miss Nye here, right? She's had an incredible amount of education and training, and that education does not come for free. Okay, it's very expensive. And why would this person, right, or any person for that matter, put their reputation and their credentials, their licensures, their certifications, any of that on the line for some farmer who's sitting in prison in Iowa? Okay. Even with Dr. Dorothy Lewis, I believe that if Dr. Dorothy Lewis had interviewed Letitia in her prime, in Dr. Lewis's prime, I believe that she would never have ended up being a witness for the defense. I really don't. I think what happened with Dr. Dorothy Lewis is, I think that I think that I think I don't really know how to put this. Rachel, I feel like the criteria that Dr. Lewis actually requires from a potential, uh, for her to testify on this witness's behalf. I don't feel like I feel like if she had been in her prime, I feel like I said, I think she would have seen in that interview that she had with Letitia, where Letitia tries to be Maria Sanchez. I think she would have seen that coming as BS a mile away. I think also part of the other issue is one of the things that Dr. Dorothy Lewis looks for in diagnosing potential dissociative identity disorder is a brain injury. And while there was some documentation supporting that Letitia had some type of head injuries, right? The unfortunate situation is because of Letitia's past behavior, um, specifically during transport from North Carolina back to Colorado, and her attacking um, one of the officers with a can of Monster Energy drink, an unopened can, full can. I think that because because of that, they would not allow Letitia to have an MRI, which is something that Dr. Dorothy Lewis uses in to help her diagnose dissociative identity disorder. And I think that um, because there were, in lieu of that, because there were supporting documents of Letitia having a head injury, I think that she was willing to say, okay, maybe I don't need the MRI because there's other supporting documents. And I think that's how we got where we were. It makes me sad about Dr. Dorothy Lewis that Letitia was probably her last case, because she really was. If you watch Crazy Not Insane and hear her backstory, she was really on the cutting edge of studying um, and making recommendations for juveniles in the criminal system. And she really had some really innovative and um, great ideas. And so it makes me sad that Letitia of all people was her last case. Okay. I don't think this woman is like, I don't think they paid I don't think they swayed her opinion by money, is what I'm trying to say at all. I think she came up, I think they gave her the evidence. I think she looked at it, and I think she came to whatever conclusion she's going to come to.
Well, oftentimes I've been a forensic biomechanical engineer for almost 15 years. And my role is essentially if there is a person that has some sort of diagnosed injuries due to mechanical forces, it's my role oftentimes is to determine the mechanical cause of that injury, and how and if it relates to the subject event.
What does your work with Robson Forensics entail?
I run scientific investigations. So again, I'm one of the biomechanical engineers on staff. I'm a full-timer. I'm the head of the biomechanical engineering group. I'm the head of the medical device group, and I'm also the director of engineering there.
You said that your company conducts investigations. Who do you conduct those investigations for?
It depends.
What kinds of clients does your company have?
Oftentimes, our clients are for litigation, but we are a neutral third-party firm, so we conduct investigations for both. If you're talking about civil, it's going to be plaintiff or defense, and for criminal, prosecution and defense. And we also do, non-litigation type investigations as well.
Is there a type of client that is, for the cases that you work on, is there one side or the other that your firm predominantly works for?
No, we're probably pretty even. I know for myself, I'm probably in civil cases 60%, 40% plaintiff defense, but my testimony is probably about equal, 50-50.
You've explained to us what biomedical engineering is. Is that a subspecialty within the more general field of engineering?
Yes, if you think about the classical disciplines, you have civil, mechanical, electrical, biomedical is, again, one of those classifications under the overarching heading of engineering.
And is this a field that graduate students study specifically in school?
Oh, yes. Undergraduate, graduate, professors, industry, medical, biomechanical engineers are everywhere.
Are there biomechanical engineering university programs here in Iowa?
Yes, University of Iowa has a very renowned biomedical engineering program. Actually, the president of our firm is a graduate of that program.
Now, you talked about your degrees. What kinds of courses have you taken in the context of your study that has related specifically to the medical aspects of biomechanical engineering?
So I am the interface between engineering and the human body. Therefore, I have to understand not only engineering and physics concepts, I need to understand the anatomy of the human body. So I take the same anatomy courses as medical doctors do. Cadaver labs, I've held human body parts in my hands, not only for schooling, but for my actual work in my studies, part of my theses and contract work as a research scientist.
Are you familiar with the field of injury biomechanics?
Yes.
What is that?
So injuries are specifically defined in biomedical engineering as a failure of biological tissue. As an engineer, it's also my job to understand how tissues fail, so material science aspects, because part of engineering is understanding and developing and designing using materials. Therefore, we have to understand how they fail.
Have you worked in your career on issues that involve injury biomechanics?
Absolutely, yes.
And can you give us some examples of situations that involve an investigation into injury biomechanics?
Well, just in my forensic career alone, aside from my research scientist years as in my graduate program and as well as consulting projects, in my career at Robson as a forensic engineer, as I said, oftentimes somebody's got some sort of claimed or diagnosed injury, and there's either competing scenarios of how it happened, or you find a body and there's injuries to it and somebody needs to know what happened to it. What kind of forces and motions did that body sustain, experience to get those injuries? That's where I come in.
Do you have research experience in the field of injury biomechanics also?
Yes.
And briefly, what has your research into that field entailed?
Well, a lot of my research had to do with, well, again, it's about the human body and how it functions, but also how to make it better, right? So when you're learning and part of the evaluation process for, say, joint prostheses, you have to understand how the tissues respond and how they failed in the first place, and how they will respond with the devices that we're developing.
Have you done research specifically on issues that have involved lower extremity biomechanics?
Yes.
Are there any differences in lower extremity biomechanics as opposed to other types of injury biomechanics?
So if you look at my CV, predominantly my publications are in, they're all engineering related. I have eyes, I have lower extremities, I have hips, knees, but the fact is a human tissue. Right, so human tissues, being materials failure, have a specific type of failure generation when it's applied to particular sets of loading. And even though you publish in one area, doesn't mean that that's the only area you work on. I've written a grant for spine research. I'm part of the Orthopedic Research Society, a member of the spine section, a member of the orthopedic implant group, as well as other memberships in other societies. And this is all in addition to my work as a forensic engineer for almost 15 years.
All right, I'm going to show you what's been marked as Exhibit 285.
Wow. Did you guys hear all that? Like, she researches and, to benefit, basically mankind, womankind, humankind, for prostheses and stuff like that, in addition to working on cases like this. Like, this is a busy bee, okay? She makes me feel like super lazy. Yikes. All right, here we go.
And let me know when that's in front of you, Doctor.
Yes.
If you need us to scroll through this, let us know. But is Exhibit 285 a true and accurate copy of your CV and your reports in this case?
Well, I only see the first page.
Let me show you just a paper copy of that, if I could. Do you need this?
I may. Thank you.
The top document in what's been handed to you should be a copy of Exhibit 285. And if you could just look at that and let me know if that's a true and accurate copy of your CV and your reports for this case.
She makes me feel like while I'm sitting here running this stream, I need to be doing about 50 other things. Do you know what I mean? Like I should be running this stream, gathering data for the Kai documentary, clipping, editing, figuring out music, all the things, and also working on a different documentary at the same time. I feel very inadequate. Here we go. Also, I appreciate that she's slipping. Look, this is her CV. Okay. This is essentially her LinkedIn. All right. This is all the things, all of her qualifications, all the things she's done, all the places she's worked, all the things. Okay. And that was a substantial amount of pages that she flipped through, but I appreciate her being careful to make sure that before she answers, she flips through each and every single page. She's very thorough. I appreciate that.
Have you finished looking at Exhibit 285?
Yes, just briefing over it. It appears to be, that is my current CV. It needs to be updated, but that's what I have right now.
What is not contained in the copy in your CV? What is not updated about your CV that's reflected in Exhibit 285?
I've been meaning to do it. I just haven't had time. I've had numerous guest lectures since then. I've had presentations to medical facilities. I present to medical facilities, to fellows, to surgeons, to medical staff. So I definitely know that I did a presentation for Grand Rounds and didactics for the Scripps La Jolla in San Diego. I've had multiple guest lectures, and I've also recently just ran a one-day workshop for a large sports manufacturing company talking about injury biomechanics.
Now, you mentioned that you work for this company, Robson Forensics. Is that your only current employment?
That's my full-time employment. I work at a gym for fun.
Oh my gosh!
That sounds like a passion project. Not
I need to stop her right now, bruh. I work at a gym for fun. Hold on a minute. There has got to be something in here. There's not. That I can play. No, I don't have anything that adequately would represent. And listen, I'm not laughing like I'm not making fun of her. I like, when do you sleep, ma'am? There's only 24 hours in a day. Like, I'm having a whole shame spiral right now. It's not your fault, ma'am. It's mine, because I probably could be putting my time to more efficient use. Oh my goodness.
Something you do for money.
I mean, not for money, but I do get paid.
Is there anything else you're doing for employment currently?
No. That is, I mean, so it depends. Depends on guest lectures. Some facilities will pay me to do guest lectures. That sports manufacturing company paid me to conduct a one-day workshop. So do I have constant, but I have these employment opportunities.
Does your salary with Robson Forensics depend on the outcome of any of the cases that your company consults on?
No, regardless of the cases I have, the number of cases, or the outcome, my salary stays the same.
All right. Do you work on any, or have you worked on any cases where ultimately after the work that you've performed, the client elects not to use your opinions?
Yes, that is not unusual.
Is that a concern for you or your company when that happens?
No, not at all, because we are third-party investigators. So whatever the science and the investigation yields, that's the findings. Whether it's, say, good or not favorable for the client that retained us, that is our answer.
Have you been qualified by courts in the field of biomechanical and biomedical engineering?
Yes, by federal as well as numerous state courts. Yes.
Have you ever had a court determine you were not qualified as an expert?
Not that I know of, and that recently came up at a trial I was at, and they actually ran my name through all the databases that attorneys have access to. And in almost 15 years, they did not find one motion that was ever successful in disqualifying my qualifications or my opinions.
Your Honor, obviously I'm a pro hoc attorney here, so I'm less familiar with the Iowa procedures. This is the point where I would tender the witness as an expert, but I understand that's not the court's practice here. But I don't know if this is the point at which the court would offer a voir dire.
Any additional record that the state wishes to make at this point?
Your Honor, the state stands by its prior objections as it related to the use of specifically Dr. Ngai's first report as it would qualify as vouching. I believe that that shouldn't be considered here. We do have a question as to what would be included in that binder. There's portions of it that are not appended to Exhibit 285, so I think now would be potentially an opportune time to take our afternoon break.
Okay, and I think at this point we were just taking up the expert witness issue, and I was just asking if there was any additional record you wanted to make.
No additional record other than our prior rules. Obviously, as Mr. Brown noted earlier, we're not a Daubert state, so.
Yep, okay. And again, certainly the court believes that the witness is qualified, so I don't think we have any problems there. I understand we might have some issues with regard to Exhibit 285, and it sounds like the state wants to clarify that. Why don't we go ahead and take about 15 minutes for our afternoon break at this point. Doctor, you may step down. We'll plan on picking back up hopefully about 2:45. Court is in recess.
Okay, yeah, they're gonna.
All right, we'll go back in the record. Dr. Ngai, I would just remind you that you remain under oath. Ms. Thompson, whenever you're ready.
Thank you, Your Honor. I think before the break, and during the break, we conferred with the state.
Rachel says she's going to take a spin class during the break. No, Rachel, she's going to teach the spin class during break. Bless her heart. She is a busy bee.
About Exhibit 285, and we are seeking to offer Exhibit 285 into evidence, which is Dr. Ngai's CV and her report.
Any objections to 285?
Yes, based on hearsay grounds, Your Honor, and for the reasons stated earlier during our off-the-record discussion in chambers.
I will take those objections under advisement. We'll continue for purposes of this examination so that we can keep moving. Go ahead, Ms. Thompson.
And, Your Honor, we have a binder of materials if the witness needs to reference them, which the state has looked at.
Okay, thank you.
Dr. Knight, you were present in court for Dr. Cruz's and Dr. Hammers' testimony, is that right?
Yes.
And you've heard some testimony over the course of the last 2 days about the scientific method.
Yes.
Is the scientific method a process that you apply in your work?
Absolutely. Sorry, I heard about the description more so today from Dr. Hammer's testimony.
Now, earlier, well, let me ask you this. Are you familiar with something called a biomechanical investigation?
Yes, absolutely.
What is that?
It's a scientific investigation to often determine the mechanical cause of an injury and if and how it relates to a specific event.
Do you apply the scientific method when you perform a biomechanical investigation?
Yes, absolutely.
I think that this is something that an expert witness like this is something that Boone wanted but did not get. Let's go.
And I don't want to, without going into detail, can you just tell us briefly what the steps are that you follow when you perform a biomechanical investigation?
Sure, yes. Just like all of us have taken in elementary school, if you remember back to your days of science, the scientific method is a foundational methodology to ensure that experiments and investigations are run so that they're repeatable and reliable. The first step is to have a hypothesis, a purpose. The next step is to develop a hypothesis or hypotheses. You can have more than one. The next step is to have materials and methods, right? So reviewing materials, gathering information, and then conducting necessary analyses to test those hypotheses. And based on the results of your analyses, then you can arrive at conclusions that then address the hypotheses that you set forth and specifically the purpose.
Dr. Nye, are you going to testify to opinions that you hold as to Mr. Mullis's case?
Yes.
And are the opinions that you're going to provide in this testimony opinions that you hold to a reasonable degree of biomechanical certainty?
Yes.
How did you first become involved in Mr. Mullis's case?
I believe that one of the attorneys for Mr. Mullis contacted Robson Forensics.
And without discussing any conclusions that you reached, what was your initial, what was the initial purpose that you were, what was the initial work that you were asked to do in this case?
Sorry, I didn't finish. Once they contacted Robson Forensic, the inquiry came in, and then I was assigned to the case.
And I'm sorry, go ahead.
No, it's okay.
I was just going to ask what you were assigned to do initially.
Okay. So so after that, we typically speak to the person that called us to determine whether or not I have the expertise that is necessary for their specific investigation. So in this case, my purpose was basically at that time to determine the mechanism of specific diagnosed injuries in Ms. Mullis.
Were you originally contacted to act as a peer reviewer for another biomechanical expert?
Initially, that's how it turned out.
All right. And did you issue a report at that stage of your involvement in this case?
Yes.
At some point, did your work in this case change?
Yes.
And how did it change?
So initially, as a peer reviewer, I'm reviewing someone else's investigation to make sure that it is technically sound, following all the steps of the scientific method, and applying the engineering and scientific principles appropriately. I don't conduct the investigation myself. I'm just overseeing, essentially, the technical aspects. When that changed was when I was asked to conduct my own independent investigation.
Is the report that you originally provided peer review on a report for someone named Dr. Susan Bully?
Yes.
And Your Honor, based on the testimony, again, we'd seek to admit Dr. Bully's report, but we would ask to defer argument on that issue, Your Honor.
Understood.
For your investigations, I'm not talking about the stage of this case where you were a peer reviewer, talking now about when your work in this case changed. Did you conduct a biomechanical investigation with respect to Ms. Mullis's injuries in this case?
Yes.
And you described earlier your process of conducting a biomechanical investigation. Did you follow that process in your work in this case?
Yes.
You told us step one is to identify a purpose. What was your purpose?
My purpose, initially with reviewing some basic information, was to determine whether the mechanism, or generally the forces, necessary to cause Ms. Mullis's diagnosed injuries were generated due to a swinging stabbing event, as was presented in the criminal trial transcripts that I reviewed, or whether it was due to a falling incident, which multiple records indicate, such as a 911 call.
Is a biomechanical investigation something that you can do on the spot?
No.
What does that process entail in terms of time?
Oh, it depends case to case. This is a very complicated case. It requires a lot of consideration and steps in reviewing case materials, the physical evidence, looking at 3D dimensional analyses, everything involved, the people, the diagnosed injuries, the implement, consideration of the spaces, the space involved, the mechanism of the injuries, scientific and medical literature review, calculations, applying scientific principles such as conservation of energy and laws of physics. It is a very arduous investigation sometimes.
I understood that from your description of your purpose that you were evaluating competing hypotheses in this case.
They weren't competing necessarily, they're just different.
But multiple
Yes.
possible hypotheses is what I meant.
Multiple proffered hypotheses, yes.
Understood. And I know that's step two of your process as you described. I want to come back to that, and I want to start with what case materials you reviewed in this case. You mentioned that you reviewed a report from Dr. Susan Bully, is that right?
Yes.
What else did you review in terms of case materials other than Dr. Bully's report?
When I conduct my own investigation, I have to review all the case materials myself. So that includes all incident information, specifically the police department documentation, photos, records, reports, interviews. As we established, I'm not a medical doctor, therefore I rely on the medical diagnoses set forth in the medical records. And of course, when I talk about all incident information, I'm referring to photos and documentation. So I'm looking at information that tells me what has happened in the incident because I wasn't there, and what the claims are.
Did you rely on medical materials from Dr. Kelly Cruz and Dr. Thompson in Region Medical Center?
Absolutely, yes.
Did you review any accounts from Tristan Mullis or Todd Mullis in conducting your investigation?
Sure, I reviewed, like I said, I reviewed the police documentation, and there are multiple interviews in there.
Right.
See, now I think that this is important, okay? And I've said it like 11 billion times, so I'm just going to say it really quick. Regardless of the bias that may be present in Todd and Tristan Mullis's interviews, I think that it's important to listen to what it is they said to either prove or disprove what they said, if that makes sense, right? If Todd said that the corn rake was positioned in Amy Mullis's back, and and he describes it, I think it's important to take that information in and at least attempt to determine whether or not he's telling the truth. See, that's where I think this, in my opinion, should have started, right? Because I wonder if Dr. Cruz had done that, if the outcome may have been different. Maybe it wouldn't have been. Maybe she would have listened to what he said, how he described I keep wanting to say pitchfork, but the corn rake, how it was, the position it was in Amy's back, right? And then she could have looked at the external injuries and the internal injuries and compared and said, okay, yeah, it happened the way he said it did, or it didn't happen the way he said it did, and here's why. And it just, I just don't understand why that wasn't done, especially because, yes, they live in Iowa. Yes, they deal with farming accidents on a frequent basis. Okay. But I highly, highly doubt. I wonder if there is a way we could find out the statistics of the amount of farming accidents, and then on top of it, farming accidents with a corn rake. Like I wonder if there's a way we could find that out, or maybe it gets discussed later on in the hearing. I'm not sure, but I'm curious about that because I think it makes a difference. I feel like that this is such an unusual case that extra steps should have been taken. That's what I'm saying. For Amy's sake, let's say that Todd did do this, right? Why would you? I would want every I and every I want every I dotted and every T crossed, because if somebody intentionally, purposefully did this to Amy, took her life in this way, I would want justice for her, and I would want there to be no questions. The defense is always going to attempt to raise reasonable doubt, but I feel like if you've done a thorough job from minute one as the prosecution team, and that includes law enforcement, right? Then it closes the door little by little by little as the case is presented to any measure of reasonable doubt that the defense might inject. And I feel for both Todd Mullis and Amy Mullis's families, right? Because they're still dealing with this all these years later, and it's not just the pain of the loss of the loved one that they're dealing with. It is the lack of finality in this case.
Did you, in order to reach your determinations, assume that those accounts from Tristan Mullis and Todd Mullis were true or false? Or did you depend on a determination that those accounts were true or false?
No, I don't rely on that. That's why science is fundamentally based in science. It's based on physical evidence, application of physics and engineering principles, and not based on subjective accounts. Now, there's always competing witness testimony. I might do my analyses and go back and compare to what was said or stated, but I don't use that as a basis for a starting point.
Did you rely on any photos or documents from the Delaware County Sheriff's Office?
Yes.
What did you look at?
They had information regarding the shed, the rake, the clothing. They also had photos of Ms. Mullis's body, and they had, dimensions. They had dimensions of the shed as well.
Did you conduct your own inspection of Ms. Mullis's clothing?
Yes.
Meaning you yourself physically looked at it?
I myself physically looked at it, yes.
Did you yourself physically look at the rake in this case?
Yes.
Did you yourself go to inspect the shed or any other buildings on the Mullis farm?
Yes, I went to visit the farm and the shed.
Did you rely on any opinions of Dr. Jennifer Hammers in reaching your conclusions?
Partly, again, a lot of her, again, the diagnosis of injuries, as we heard today, her and Dr. Cruz agree on the injury pattern.
Did you rely on any other opinions of any other experts in reaching your opinions in this case?
No, not that I can think of, no.
All right, and you said that you relied on the injury pattern in this case from Dr. Cruz and from Dr. Hammers, is that right?
Yes,
And you've heard the testimony from both of those witnesses so far about what that injury pattern was?
the testimony as well as the autopsy report, yes.
Understood. And from the testimony from Dr. Jennifer Hammers today, was the testimony that she gave today about the injury pattern on Ms. Mullis's back, did that comport with your understanding of what that injury pattern was?
Yes, it comported with what Dr. Cruz reported in her autopsy report and prior testimony.
All right. Now, you heard Dr. Hammers give some testimony about other injuries to Ms. Mullis besides these 6 wounds, wounds A to F on her back, is that right?
Yes.
Did you consider evidence about any of those other injuries on her body in reaching your opinions?
Yes, I mean, I look at all the injuries that are diagnosed on a person. However, the information provided were there are already explanations for the other injuries, so I was asked to focus on the penetration wounds.
Are you offering any opinions one way or another about any injuries on Ms. Mullis's body besides wounds A to F?
I specifically was asked to focus on the penetration wounds, so that's where I spent my investigation time.
Okay. I'm going to show you, and there's been testimony about this, but so I want to briefly show you Figure A, which we've talked about earlier in these proceedings. Do you have a figure in front of you?
I do.
All right. What do you understand Figure A to represent?
Figure A is a profile view, so a side view of the basically the human torso. It doesn't have a head, doesn't have legs, doesn't have arms, and what it demonstrates is wounds A to F, the penetration, relative penetration depth relative to each other, as well as the orientation. When I say orientation, I mean the trajectories through the body.
And I want to also show you, just for my colleague, A8208. I think we'll just call this demonstrative B for the record. It's A8208. We'll 208, and we'll just refer to this as demonstrative B. Is there another
Yes.
document in front of you? Did you hear testimony about this demonstrative earlier today?
Yes.
Does the information reflected on demonstrative B reflect your understanding of the measurements of the injuries on Ms. Mullis's back?
Yes. Well, part of them, only injuries A to B, yes, A and
All right.
B.
All right. I'm also going to show you what I guess we'll call demonstrative C, which is A8207. Is that in front of you?
Yes.
And does this reflect your understanding of the measurements of wounds B through F?
Basically the linear distances between each wound.
I'm also going to show you here what we're going to call demonstrative D.
I have a figure out.
All right. Does demonstrative D, third time's a charm, show you the measurements and the depths of wounds B through F?
It is a picture of the back, and it shows me B, C, D, E, and F. It shows me the relative depths of each wound, the linear distances between each of those wounds, and essentially the size of the wound.
And does that reflect your understanding of those aspects of the injury pattern on Ms. Mullis's back?
Yes, based on Dr. Cruz's autopsy report. It also shows the abrasion above wound D.
All right, and we've had a lot of testimony about these wounds, so I want to ask you about what aspects of these injuries, I want to ask you about some specific aspects of these injuries. What characteristics of the wounds A through F that we've been talking about are important for your biomechanical analysis?
So we can start superficially, more on top of the skin. And as Dr. Hammers testified today, that we heard also reported in Dr. Cruz's autopsy report, each of the wounds have a specific orientation on the wound. So A, B, and C are oriented 10 to 4 o'clock. D has an orientation that's different, about 8 o'clock to 2 o'clock, and E and F are oriented 11 to 5 o'clock. Additionally, the information about the wounds around each puncture, showing that A and B look more diffuse, as Dr. Hammers described today, and then and then the spacing between each wound. Now we go internally, then the trajectories are important. To understand where they start and how they move through the body gives an indication about the path that they traveled. And understanding that A to D, again, has a trajectory that's through the body that's near horizontal to the long axis of the body, so perpendicular to the long axis of the body, though slightly downward, and E and F are sharp upward.
Okay, I just need to pause briefly for some fair use commentary. I was talking in the side chat about the terms that they're using here and why I think people, it's me, I'm people, are resistant to this being an accident. I think if they changed the language instead of fell on to landed on, I think people would be less resistant because truly it's two separate events if you think about it, right? So first you have whatever it was, and I suspect it might have been the lip of the floor of the shed being higher than the ground. And I think Amy being just maybe like a week, I think, or maybe 5 days, something like that, post-op and being on medications, I think may have impaired her, and she may have been so focused on going into that shed to retrieve, because she was interrupted in her work. She had initially gone to that hog barn with one purpose. She went there to clean the light fixtures that had fly fecal matter on them. That's what she went to do. And she was interrupted to go and get this pet carrier. And so likely what she was saying, she might have just been distracted thinking, let me just go grab this real quick so I can get back to what I'm doing because I got a lot to do, right? I'm going to be in there for 11 billion hours if I don't hurry this up. And I think it's very likely that the first incident is the trip, or the fall, like she caught maybe her foot or something on that lip in between the ground and the flooring of the barn. And then she started to fall, right? So there's the trip, the fall, and then where she landed. And see, I think if it was described in those terms, 4 days. Thank you, Clicker. I knew Clicker would show up eventually and help me out. Thank you. I appreciate that, babe, so much. So I think that if it was spoken about in those terms, like she ultimately landed on the corn rake instead of fell on the corn rake, I think people, like I said earlier, to me, I'm people, would be less hesitant to start to listen to this in terms of potentially being an accident. That's what I think. Okay, let's finish. Let's listen to what Dr. Ngai has to say.
Are there any other aspects or characteristics of those wounds that's important to understand that was important for you to understand for your biomechanical analysis in this case?
Well, the abrasion as well is something that I consider.
And why is that?
It's just another piece of information.
You heard testimony from Dr. Hammers that in terms of the orientation of these wounds, that she grouped them into wounds that have different orientations. Is that right?
Yes, they self-group. Yeah,
Right.
10 to 4 o'clock, A to C, D's on its own, and E and F.
All right. So in general, and considering your testimony about your biomechanical investigation, you're discussing and considering human anatomy and reaching your decisions in this case. Is that right?
Yes.
And if you're not a doctor, how are you able to do that?
As we discussed, I take I'm the bridge between engineering and medical, the biological tissue. So I, again, take the same anatomy classes as medical doctors. I take cadaver lab. I've taken cadaver lab. Have access to cadavers through my work at hospitals. I've held human body parts in my hand. I mean, that's part of my job, is to understand the human body and how it fails.
Did you hear some testimony from Dr. Hammers that these injuries, these penetrating injuries, are from blunt penetrating forces?
Yes.
And is that important to your analysis?
Yes.
Why is it?
Because the mechanism, when I talk about mechanism of injury, I'm talking about the type and direction of forces necessary to cause an injury. We're not talking about magnitude anymore. Oftentimes when I say force, people just think it's a number, but it's much more complicated than that. So type and direction designates a mechanism of injury. And blunt force injuries have different mechanisms than sharp force injuries. So blunt force injuries fail, the tissue fails due to tensile loading. Essentially, you add tension to the tissue and it overloads past its failure point.
Before we go through the possible hypotheses that you considered in this case, I want to talk to you about your investigation of the rake and the clothing in this case. So I think it was your testimony a minute ago that you examined yourself the actual rake, and that's connected with this case. Is that right?
Yes.
Did you take your own photographs and your own measurements of the corn rake?
Yes.
I'm going to show the witness what's been marked as Exhibit 929.
I know that this hearing is over and has been over for several days, but I would like to make a motion that the exhibits are shown to the rest of the class. Thank you.
Do you recognize Exhibit 929?
Yes.
What is it?
It's a photo I took when I went to inspect the rake.
And is that a true and accurate copy of how the rake looked when you examined it?
Yes, it appears to be.
All right, Your Honor, we'd offer Exhibit 929 into evidence.
Any objection?
No objection, Your Honor.
929 is admitted.
You understand that the investigation into this case suggested that this corn rake caused the injuries in Ms. Mullis's back, is that right?
Yes.
Did anything about your investigation suggest that wasn't true?
No.
All right. You measured the corn rake when you looked at it?
Yes.
And what, if anything, did you note about this corn rake that was important for your analysis in this case?
It's important for me to understand the geometric, dimensional, and intrinsic properties of the rake. It has a specific shape, right? So if you stand the rake on its wooden handle on the very end, the tines themselves essentially point sideways. So not quite 90 degrees, a little bit lower than 90 degrees, so closer to the ground. And the spacing between the tines, there's 4 tines, as we've all heard, is a little less than 3 inches. The whole rake is about 37 inches long. It weighs about 2.6 pounds, and the center of mass of the rake is closer to the rake head, so it's basically top heavy. And it's metal, so the head of the rake is metal, the handle is wood, so it is essentially stiff, right? This rake, for me to understand, is a stiff implement relative to the human body. So if you're going to put the two together, it's the human body that's going to deform.
I want to show you as well Exhibit 938. Do you recognize what Exhibit 938 is, Dr. Ngai?
Yes.
What is it?
It is a view from the top. So if I'm looking at the tines, and the tines like towards my face, I'm looking at the top of a tine, essentially.
Is the tine in that photograph for, I don't know the term you would use, but in a caliper or a measuring device of some
It is in a
kind?
caliper, yes.
And the tine is in the middle of that caliper?
Yes.
Does Exhibit 938 truly and accurately depict a more close-up view of one of the tines of the rake at the time you observed it when you examined it?
Yes.
All right, and at this time, Your Honor, I would offer Exhibit 938 into evidence.
Any objection?
No objection, Your Honor.
938 is admitted.
As to this, I'm sorry. Specifically as to the tines of the corn rake, was there anything about the properties of the tines that was important to your analysis?
Yes, looking at the tips. Again, the spacing we talked about, the length, the shape, that it's stiff, but again, the tips themselves were they're not sharp, they're not pointy.
And why is the fact that in your view these are not sharp or pointy, why is that important to your analysis here?
Because as we discussed, it has a different mechanism of injury. And you know, they're kind of flat in a sense, just the way Dr. Hammers described today. If I were to compare them to something that people are experienced with, they're essentially.
I'm just going to go back and rewind so we can hear the question and answer portion, but I wanted to answer this question or talk about this question. So Nicodicus says the rake was leaning against the wall. How far away from the pet carrier was Amy found? She would have had to kick the rake or knock it over for it to be tines up. Was she reaching and fell? Okay. This is one of those questions that we don't fully know the answer to. Okay. In his original trial, Todd Mullis testified that he had placed the corn rake just inside the door of the red barn. However, and maybe Clicker knows this, I cannot remember how it was positioned. Where was it positioned, handled down, tines up, or was it positioned handle up, tines down, and turned so that the tines were facing out? That I don't know. As far as the pet carrier is concerned, there is no evidence that Amy ever made it to where the pet carrier was located. There are pictures of the pet carrier, and I showed those yesterday. And it does appear from those photographs that the pet carrier has not been moved at all. I mean, it is in a like a straight position, like if you're reaching for something and you just get it, but you don't quite get it, how you'll move what it is you're trying to reach, but you don't completely, remove it from the shelf. It doesn't look like that. It looks like it has not even been budged at all. So there's no evidence that Amy ever got to the it was not gotten to. I don't know why I trailed off there, probably because I got distracted by Clicker answering his question. She says, Bendy, that information was not ever disclosed. It was never that specific with how it was in the barn. See, and that's important. I mean, I think we would have to know that. But again, even if we did know that information, right, who would that information come from? Well, it would come from Todd Mullis, okay? He's the one that put the rake there. He's the only one that can say the rake was there, but it was days before. And it is possible that it's possible that it was moved in the interim. We just don't know. And it's a bummer because those details would be important. Okay, let me rewind this just a little bit. Okay. All right, let's rewind.
We talked about the length, the shape, that it's stiff, but again, the tips themselves were they're not sharp, they're not pointy.
And why is...
I forgot one thing, and Neat Noodle made me remember it. So Neat says those rakes have curved teeth, so it potentially could have been knocked to the floor when she opened the door and landed tines up. That's an excellent point. So the way that this shed was, the door has been described as frozen open, okay? But when you look at the pictures of this red shed and the amount that the door was open, it would not have been open enough for Amy to have brought the pet carrier out. So what I wonder is, was the rake jostled when she was attempting to open the door? Because likely she would have tried to open the door from the outside, right, to go in and then bring out the pet carrier. I feel like when a door is like that, it would be easier to try to get it from the outside to open rather than try to get it from the inside. And so that's just my hypothesis. I don't have any scientific proof beyond, I don't have any scientific proof or evidence because it just simply doesn't exist in this situation. Those were questions that I don't think were ever really asked. All right, here we go.
Is the fact that in your view these are not sharp or pointy, why is that important to your analysis here?
Because as we discussed, it has a different mechanism of injury. And you know, they're kind of flat in a sense, just the way Dr. Hammers described today. If I were to compare them to something that people are experienced with, they're essentially kind of like a flathead screwdriver, if you think about it. And if you compare the cross-sectional area of the tip, which is in this picture, for a 1/4 inch wide flathead screwdriver, the tips essentially have a bigger surface area than the tip of a flathead screwdriver.
Why does that matter?
Because in the biomechanical studies, flathead screwdrivers are considered blunt instruments.
Is it, in your assessment, this is blunter than a flathead screwdriver?
This is blunter than a flathead screwdriver based on the measurements, yes. In addition, it's rusty, so it's not smooth, it's not new, so it's not perfectly machined, you know. So again, this is something that has wear and tear on it.
Why does that matter?
Again, wear and tear, just like knives, you know, you use them over time, they get more blunt.
Now, you said in your testimony that the mechanism of injury is different for this type of object. Different from what?
Well, different from sharp force, right? So if you talk about sharp force, tissues fail under compression. So this is basically a tensile loading. So you put something that's blunt against the skin or any kind of material, and you push through it, it basically generates a tensile loading, and it's the tensile loading that causes failure. And why that's important is because in literature, it provides information about the thresholds for human skin to fail under tensile loading.
Just for clarity, I feel like the way that I'm interpreting and understanding her testimony here is we're talking about a cut, like a laceration, a smooth cut, versus a tear. So if you think about taking a flathead screwdriver and a piece of fabric, like a sheet, like a bed sheet, okay, and you try to push the flathead screwdriver through the sheet, it's going to tear and rip the fabric. It's not going to be a smooth edge on where it came through the way it would be a smooth edge on if say scissors were used to cut. I think that that's what we're talking about here.
You're using a lot of scientific terms there. So when you talk about the tensile loading that would cause human skin to fail, in layperson's terms, what does that concept mean?
Like ripping apart. You know, if you were to, you know, again, rip something apart rather than push it together, biological materials are anisotropic, and they have different characteristics and different failure mechanisms and different thresholds for failure depending on how you apply the force to it.
I want to talk more about how those concepts apply in this case, but I want to ask you first about your evaluation of Ms. Mullis's clothing. You had a chance to inspect yourself, Ms. Mullis's clothing, is that right?
Yes.
Did you evaluate the different layers of clothing that Ms. Mullis was wearing at the time she was taken to the hospital in this case?
Yes.
And was there anything relevant to your analysis that you noted when you inspected her clothing?
Looking at the holes, again, this is information and evidence that needs to be considered. So the undershirt and the sweatshirt had the same number of holes as Dr. Heimer has described today, 5 of which were in the area of the 5 of the wounds. Remember, she has 6 wounds, and there was a cluster of holes in the sweatshirt and the undershirt that was consistent with being caused by a single tine. Additionally, the coat itself had the same area of the location of wounds except for wound D. So again, we have less holes in the clothing than there are in the body.
When you examined the jacket that Ms. Mullis was wearing at the time she was taken to the hospital, how many holes did you see in that jacket?
In the location of the wounds, 5.
And when you examined the clothing, did you make any holes in it?
No.
Can you yourself account, well, let me ask you this. Did you hear testimony from Dr. Cruz that at autopsy they identified 4 holes in a photograph?
Yes, I know that photograph.
All right, and can you personally account for why there is a difference in the number of holes that you saw and the number of holes that were photographed at Dr. Cruz's autopsy?
All I can say is that the photos from the autopsy, that additional hole wasn't as prominent as when I went. When I went, that hole was prominent, and it matched up with the holes on the underclothes.
In general, why were you inspecting the clothing that Ms. Mullis was taken to the hospital in?
Again, it's all information. It's important to consider the physical evidence when running an investigation and making conclusions.
You've talked a second ago about the tensile strength needed to break human skin. In a biomechanical analysis that involves someone wearing clothing, is it important to understand characteristics of the clothing?
Yes, absolutely.
And why is that?
Because different clothing have different properties. Again, it's material science, right? So different materials will have different failure thresholds. And how it applies here is that Ms. Mullis was, as we've heard, was wearing multiple layers of clothes, one being a very thick, I guess it was described as a Carhartt jacket with fleece inside based on my inspection.
I want to go back and show you demonstrative D. In total, with your understanding of the wound pattern that Ms. Mullis had on her back, the rake that we've been talking about in her clothing, did you draw any conclusions about the mechanism of Ms. Mullis's injuries based on all of that data?
Yes, that it was tensile overload due to penetration from a blunt object.
And in layperson's terms, Dr. Ngai, what does that mean?
It means that the skin was pushed apart by something that was not sharp, and when you push it against it, it kind of pulls the skin apart, and it fails under tension. Tension is pulling apart.
Did you
So Nika Dicka says, neat, me either, but it really makes me think, is the Google search enough to seal the deal? If I heard this testimony, I'd be asking tons of questions. Okay, this is how I feel about the Google searches. I'm going to put a pin in Todd's specific Google searches till we get to that portion of the hearing, but just generally speaking. So when I covered Letitia Stauch's trial, okay, and her Google searches were introduced as evidence. While I paid attention to them, in all honesty, I wasn't as moved by that evidence. I didn't give that evidence as much weight as I did the evidence that she drove this moving van to Florida, and following the data from the vehicle itself, it put her at the bridge where the suitcase was ultimately recovered that had Gannon's body in it. And to corroborate that evidence that the suitcase was absolutely with her was her brother's. It ended up they had to switch vehicles. So he recalls that suitcase being in the original vehicle, and then Letitia herself moving it from the original vehicle to the second vehicle when she ultimately ended up driving to Florida. And he remembers her struggling with it, and he remembers offering help, and she was like, no. That evidence to me was more compelling. I gave it greater weight than I gave the Google searches, because I understand the limited information you can receive from that evidence. All they can really say about those Google searches from Letitia is they were done at a specific time, right? And the Google searches these were the specific Google searches, and they were done on Letitia's phone, but nobody can say who actually did those. That's why they're limited. They're interesting, to be sure, and I did pay attention to them, but for me personally, I gave them less weight. Going into this, for me personally, I'm going to give much more weight to physical evidence than I would to those Google searches, because they're limited in what they can actually prove. So that's just me.
Hear Dr. Hammers' testimony about the pattern of the wounds on Ms. Mullis's back with respect to the spacing of the wounds on Ms. Mullis's back.
Yes.
And did that give you an understanding of the mechanism by which Ms. Mullis experienced these injuries?
So again, the mechanism is the same. It's going to be tensile failure due to penetration by a blunt object. But biomechanically, when you look about the spacing between the wounds, and I understood that Dr. Hammers testified from a medical standpoint. I'm testifying from an engineering standpoint. Looking again at the materials, the geometry, the intrinsic properties of the rake. Intrinsic properties of the rake being it's stiff, it's not malleable relative to the human body. It has essentially fixed spacing between the tines. I can then compare it to the wounds diagnosed on Ms. Mullis's body.
And did you conduct that comparison in this case?
Yes.
And what conclusions, if any, did you draw from that comparison?
Again, similar to the medical side that Dr. Hammers testified to, when you hyperextend, your skin on your back compresses, basically it squeezes together, and when an implement that's stiff like this punctures the skin, you then lay the body flat and flatten out the body. The wounds then are spaced apart. So the wounds are going to be farther apart than the spacing between the tines, which is what we have here.
And so did this biomechanical analysis that you did, coupled with the medical information that you had from Dr. Cruz's autopsy and the spacing information that you had, did that give you an understanding of the position of Ms. Mullis's back at the time that she experienced these injuries?
Yes, that she was slightly hyperextended.
Hyperextended how?
Arching or rotated.
And you're making a motion here, and when you say that she was hyperextended, was she hyperextended on both sides?
No, I mean, the wounds are on the primarily middle. One is left, but right side. So she's twisting essentially to her right.
Is it your testimony that, because you've made a motion, I want the, record to reflect what motion you made. Is the motion that you made a motion that hyperextends your right shoulder back, bringing your elbows closer to your body?
Well, it's basically a slight twist and pulling my shoulders back, kind of like sticking out my chest a little bit.
And pulling your shoulders back, does that decrease the space between, does that decrease some of the spaces in your back when a person does that?
It just compresses the skin. It makes the skin squish together.
And would that dynamic of Ms. Mullis's back being hyperextended when she experienced these injuries, would that explain the spacing of the wounds on her back in the pictures that we've been looking at?
Objection, speculation.
Overruled, the witness can answer if she's able.
Yes, I think I've already testified to that the spacing on the wounds are bigger than the spaces between the tines. So that means she has to be hyperextended, which compresses her skin together. So when you lay the body flat, the wounds now are spread farther apart in distance.
You heard some testimony from Dr. Hammers about how she would order the way in which Ms. Mullis received these injuries, the order in which they occurred.
Yes.
Do you, from a biomechanical perspective, do you reach the same result or a different result about the order in which these injuries occurred?
No, biomechanically, I agree that A, B, and C occur in pretty much at the same time. I think that based on the analysis, D happens next, and then E and F.
And why is that from a biomechanical perspective?
Based on the clustering, again, if you look at the injury diagnosis, you have the spacing between A, B, and C, and they're in a linear pattern. Additionally, you have the same orientation on the skin, so 10 to 4 o'clock, and you have the same trajectory through the body being horizontal to the long axis of the body. Now you have D, which is much smaller, less deep, because it's only 2 inches deep, and has a different orientation on the skin. And then you have E and F, which again are clustered together because they have an orientation of 11 to 5 o'clock and the same upward trajectory. Sorry, can I finish?
Oh, go ahead.
I had a pause there.
Sorry.
Additionally, considering the intrinsic properties of the rake being essentially fixed relative to the human body, it's not going to deform or be malleable. E and F are essentially in the middle of her, and E, C, and D are essentially in the middle of her back. Those tines cannot be inserted into the body one at a time. It's kind of like if you look at the palm of your hand and you take a fork, you can't enter one prong through your entire palm without having the other 3 prongs contact you. It's similar here. We have a fixed distance between the tines. So E and F, if you're impacting the body with the rake, that a 3rd tine has to happen somewhere, and we don't have another upward trajectory. So those ones can't happen first. Similarly with D, D is essentially close to the middle of the back. You cannot insert one tine at a time. So D is not going to happen first either. So that leaves A, B, and C.
And did you hear testimony from Dr. Hammers about the theory that there could have been tines that were that were inside wounds A and B, and then have tines go into other wounds while the tines in A and B remained in A and B.
Yes.
From a biomechanical perspective, do you have an opinion on whether that's possible?
Yes, that is what happened based on the analysis that I conducted.
All right, so at this point I think your testimony has been that you identified what the injury pattern was as you understood it. You looked at the rake, you looked at Ms. Mullis's clothing. Did you also look at the shed on the Mullis farm?
Yes.
And I wanted to show you Exhibit 731.
It's up.
All right, do you recognize what's depicted in Exhibit 731?
Yes.
What do you understand Exhibit 731 to depict?
It depicts a photo inside the shed where Dr. Hammers was describing one of the walking paths, one of the very few walking paths.
You said that you yourself visited the shed as well?
Yes.
Does Exhibit 731 look like the shed, the inside of the shed, or the area of the shed that's depicted in 731 when you saw it?
It looks like it.
Why did you go to the shed and look at the shed?
Again, it's information to gather, a data point that needs to be considered.
And why does it need to be considered?
Well, if I have all these essentially different hypotheses to test, I want to understand the space in which the people or claimed people involved, how they fit relative to the spacing. So now we have to consider anthropometrics, the people claimed to be involved, now we know what the implement looks like and how long it is, and I have different hypotheses to test. So I want to know what space I'm working in. You know, am I working in a giant field or am I working in a box?
Was it an assumption that you had at the time you tested your hypotheses in this case that the interior of the shed on the Mullis farm was where Ms. Mullis experienced these injuries?
I don't assume.
I also think that this is really, really important testimony, and it's an important step in the process to figure out what happened, okay? That shed, as I understand it, was full. You know, there wasn't a whole lot of space to walk around. It was the pathways between things that were in the shed was pretty narrow. And although I think the testimony is that it didn't exactly occur in the shed, I don't know. Let me keep going. I just think it's important. I wish that we had better pictures of the inside of that red shed, like the whole red shed, all of it, every space, to give a better idea of what it looked like in there. But I do think going to the shed, if you're the one, you know, trying to figure out what happened in this case, it's your job and responsibility, right? You're hired or you are law enforcement, whatever. It's important to go and see the shed for yourself to be able to understand what did or did not. Because what did happen is just as important as what didn't happen, if that makes sense. All right, here we go.
I mean, did your opinions depend on the interior of the shed being where she experienced these injuries?
No. If I didn't have, now that I conducted my investigation, if I didn't have information about the shed, my opinions wouldn't change.
All right, so you talked about the scientific method. I think we've talked about your purpose. Have we talked about all of the case materials that you reviewed in this case and that you relied on to reach your opinions?
I believe so. The
All right.
physical evidence, yes.
Okay. And I think we skipped a step, which was developing hypotheses. And I want to use the right term that you use. I think you said that you considered different possible hypotheses. Is that right?
Well, I considered different hypotheses that were proffered in the material I reviewed.
All right. So you mentioned a moment ago that you had to take that when you conduct these kinds of biomechanical investigations, you take all these case materials into account to conduct your assessments. And before we talk about any of the individual hypotheses that you considered in this case, how did you take all this information to test those hypotheses?
So part of the scientific process, after you've developed a purpose and your hypotheses, reviewed case materials, the next part, and we now talked about the mechanism necessary to cause these injuries, the next step is basically to apply engineering and scientific principles to determine whether or not that mechanism is generated in each hypothesis, if and how.
Just as an aside, the process that, well, not as an aside, I want to ask you this. The process that you're describing, is this the same thing as an accident investigation or an incident investigation?
Yes, incident investigation.
Okay. Is what you are doing when you determine whether different hypotheses are possible, is one of the things that you have to do to decide how much force would be necessary to cause whatever hypothesis or whatever hypothesized mechanism you're considering?
No, not all the time.
And why is that?
Because as I defined earlier, mechanism of injury is the type and direction of forces necessary to cause an injury. That excludes magnitude, right? So talked about it a little bit, but types of forces are compression, so pushing together, tensile loading, which is pulling apart, shear loading, which is essentially sliding or transverse to a plane, torsion. Along with those different types of loading, you can have combinations of all those loading. Now, direction is important because the human body and all objects in are three-dimensional. So knowing that each one of those types of forces, as well as any combination of those forces, can be applied to the body in every plane, in any increment of that plane. That's what mechanism of injury means. That's first and foremost. If the mechanism doesn't match, then I don't need to do magnitude. And I've testified before, the analogy is if I'm looking for a red dress in size 5 and I find blue jumpsuit, I don't care how big it is or what size it is. It doesn't matter.
All right, so to test a particular hypothesis, you're first determining if the type and direction, if the mechanism is possible.
If the mechanism is generated first, yes.
Right, and if the mechanism is generated, do you then determine whether the magnitude of the force is possible?
Again, if it's necessary.
If you have to get there.
If I have to get there. It depends on the case.
Are there any other potential steps in your biomechanical analysis of trying to decide if a particular hypothesis can be proved or not?
Could you please repeat that?
Sure. So in testing a particular hypothesis, you determine if the mechanism fits?
If the mechanism is generated in the hypothesis provided, yes, that I've generated based on the materials.
Right, and you then determine if you need to, if the magnitude of the force could be generated.
If necessary. Again, I'm not going to say I always have to do that because case by case, I don't need to do that.
Understood. Is there a third potential step? Or are those the two steps?
I don't know what you mean by third potential step.
All right, let's start talking. Let me go on and we'll come back to this issue. To do what you're just describing, to determine the mechanism of the injury, meaning the type and the direction of the injury, what do you have to analyze?
So I already discussed the mechanism necessary for Ms. Mullis's injuries are blunt penetrating forces, which are generated by the rake. We have that she's hyperextended, and we have the orientation the rake has to be in because we know that the tines are flat. So it has to be somewhat entered when she's hyperextended and rotated. So that gives me a position and orientation of the rake on the surface relative to the injuries. Additionally, looking at the tines, how they are, again, fixed and almost perpendicular to the ground, just slightly downward, if you were to hold the rake up. If you match that up with her trajectories, I now have a position and orientation of how the rake fits into her wounds.
When you are
Hold on, I'm going to rewind that part and go back because I want to make sure that I'm understanding what she says. And Sadie says, all right, here we go. I think I figured out what bothers me about the defense attorney. Sounds very unprofessional. Since I did phone work for several years, filler words are like nails on a chalkboard for me. Then babe, I do not know how you listen to me. Because I feel like I say a lot. And I know when I'm doing it, it's because I'm trying to, my brain works much faster than my mouth. And sometimes it's difficult for me to accurately and adequately express the winning thought that needs to come out of my mouth. And I have to take a pause because I want to make sure that what I'm saying is clear, that I'm being clear about what I'm trying to say. And I find myself saying a lot, and it must drive you up a wall because I can hear myself saying, and it drives me up a wall that I even say it. I just don't really know how to stop that. I'll work on it though. All right. I want to rewind this part because I'm trying to understand the wounds. All right. And I'm going to make her go on regular speed. All right, here we go.
I don't know what you mean by third potential step.
All right, let's start talking. Let me go on and we'll come back to this issue. To do what you're just describing, to determine the mechanism of the injury, meaning the type and the direction of the injury, what do you have to analyze?
So I already discussed the mechanism necessary for Ms. Mullis's injuries are blunt penetrating forces, which are generated by the rake. We have that she's hyperextended, and we have the orientation the rake has to be in because we know that the tines are flat. So it has to be somewhat entered when she's hyperextended and rotated. So that gives me a position and orientation of the rake on the surface relative to the injuries. Additionally, looking at the tines, how they are, again, fixed and almost perpendicular to the ground, just slightly downward, if you were to hold the rake up. If you match that up with her trajectories, I now have a position and orientation of how the rake fits into her wounds.
When you are conducting the type and direction analysis, are you considering the laws?
Yes, Sarah, this is exactly it. And this is something that I have used to describe it, what's going on in my brain as well, buffering. And I know you meant that affectionately, babe, because it is. That's what's happening to me. I'm buffering. It's too much. I still don't understand. It sounds like what she's saying. And you guys correct me if this is what you're saying. It sounds like the handle of the rake had to be down, meaning that looking at the ground, not the floor of the shed, or let's look at the floor of the shed. Looking at the floor of the shed, the handle of the rake was on either the ground or the floor of the shed, and the rake head, the corn rake head, was at the top and turned so that the rake was facing outwards. The tines were facing towards the inside of the shed rather than towards the door. Is that what she's saying? Please help. I need help. Let me rewind this right quick.
Orientation of how the rake fits into her wounds.
When you are conducting the type and direction analysis, are you considering the laws of physics?
Yes,
And are you considering biomechanical and engineering principles as well?
absolutely.
All right. I want to talk about the possible hypotheses that you considered in this case. Did you consider as a possible hypothesis in this case Dr. Cruz's determination that it was possible that the corn rake was swung into Miss Mullis's body to cause these injuries?
Yes, and that was what was presented in the trial transcripts for the criminal trial, that it was swung multiple times into her body.
In your biomechanical investigation, were you able to prove or to disprove this hypothesis?
I was able to disprove that hypothesis.
And how did you disprove that hypothesis?
So again, sorry, I keep saying that, but so in every analysis, the engineering fundamentals include Newton's laws of physics, conservation of energy, and I don't know if you want me to go through the laws. I don't need to go through 1, 2, and 3 unless you want me to. But based on Newton's laws of physics and understanding the mechanism and the injury and how the rake is positioned, yes, and in considering the anthropometrics of the people involved, there is about 10.5-inch height difference between Mr. Mullis and Ms. Mullis. So that takes that into consideration.
I want to stop you there. When you talk about their anthropometrics, was that considering the height and weight of each person that would have been involved in this hypothesis?
Yes, and later on I use it further for Ms. Mullis.
Okay, I think I'm understanding this testimony even better now as to why the why the theory of Todd Mullis swinging is why they're saying it couldn't have happened. Also, by the way, good morning, preschool granny. Good to see you, babe. Welcome in. Okay, I think what she's saying is it has to do with the injuries themselves, both what you can see visually externally and what you can see internally, inside the wounds themselves. And the fact that 2 tines stayed in her while 2 tines were not in her but did re-enter her body. If somebody were swinging that corn rake in an effort to strike her multiple times, TIMES, right? One would assume that they take the swing, they hit her once, they pulled the corn rake out, they hit her again, right? So then in that scenario, the 4 tines, TINES, that went in would also need to be, they would also all 4 need to be removed. Why would he, or anybody for that matter, swing once, hit her, all 4 tines go into her body, and then they only remove 2 tines and hit her again, and then hit her a 3rd time? I think that is what the why the defense's expert witnesses, the forensic pathologist and the biomechanical engineer have ruled out that this was done by another person. Why this is not homicide, it is an accident. Because it doesn't make sense that it would be like stabbing somebody. What, you have multiple stab wounds, but one knife stays in the wound the whole time. Does that make sense? I think that's what she's saying. And Kayleen, what up, buddy? Good to see you.
Did you get the height and weight information that you used in your analysis?
The medical records for Ms. Mullis provide me a height and weight, and I actually don't remember where I got Mr.
Your Honor,
Mullis.
I am going to object to the line of questioning as beyond the scope of the report in violation of the rules of civil procedure.
We'll come back to your objection momentarily, sir. But Clicker AK says, ding, 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 you win, Jen. Okay, I just want to make sure thank you. I just want to make sure I am understanding her analysis and testimony, and I'm getting it. And call me Sadie. Don't you dare not say another word for the rest of the live. I won't be able to handle it if I don't see you in the side chat. I need your chat. I need all of you guys' chat. Please chat. All right. Let's just continue with this. It's an objection, and we're not really missing anything, whether it gets sustained or overruled. Here we go.
As it does not include the study nor the actual evaluation of Ms. Mullis's weight or any of the matters in question here. In fact, I believe that Dr. Ngai's report specifically, her second report at page 2, footnote 5 says she doesn't include the actual data and principles, and to date I don't believe we've received the specific data, principles, or force inert evaluations. I'm sorry, the force evaluations at issue for her testimony here. And so the state objects, says it's beyond the scope for purposes of the rules of civil procedure, and therefore falls outside the allowable scope of her expert testimony.
Do you wish to respond?
I thought that we conferred about this at the break, but we tendered Dr. Ngai's biomechanical investigation materials to the state in discovery. I wasn't at the case at this point, so I'll let my colleague handle this, but these materials were disclosed.
They were disclosed last year, Your Honor, and supplemental discovery, I think it was May 27th or June 4th, 2024.
For clarification, Your Honor, is this what you're referencing?
Yes.
I don't know that this is actually, as we conferred in the hallway, I believe we conferred and confirmed that most of it was Dr. Bowley's figures and expressed information. that most of this, I believe, was either copy and pasted for the portions at issue. And again, it was labeled a work in progress and never made a part of the actual expert reports at issue. So based upon the actual calculations, I do believe that we do not and have never received, as Dr. Ngai's footnote 5 notes, we have never received the actual information underlying the specific findings.
Judge, may I real
If you want to respond, that's fine. Otherwise, we can take a quick break and go off the record so you can look further into what was actually exchanged back on that date.
The applicant and the state share a Dropbox link, and this was provided to them in the supplemental discovery, as I mentioned. There's actually 2 files, and that's not a copy and paste. It's actually Dr. Ngai's work in progress of what she was doing and how she came to her analysis of, and I think it also includes like law enforcement and reports and basically her calculations and stuff.
Your Honor, I think this is this is actually, I don't think there's a dispute about what the state received. I think the dispute here seems to be about whether that's a sufficient disclosure. I think that's the issue. I don't think we dispute what was turned over.
Well, I guess I'm hearing a dispute about what was turned over. So,
And we do dispute what was turned over.
I'd like to say I heard a dispute about what was turned over. He's saying that he never received a report from the defense with Dr. Ngai's calculations and all the things that he just mentioned. You were sitting right here, and the defense is saying, we did send it to you. It's in the Dropbox, bro.
Witness.
sure.
Thank you. Dr. Ngai, you've previously been deposed and testified in other cases, including at least 24 prior times, correct?
Yes.
Including deposition timeframes recently in the Federal District Court for the Eastern District, I believe, of Texas on an estate case. Is that fair? I believe it's called Ramirez v.
Yes.
Escobedo.
I know that case. Yes.
And during that point in time, you also were questioned in your deposition about how you form the notes in question. Do you recall that? How do you take notes when evaluating the case record? Fair?
I don't recall that testimony specifically, and if you could just slow down a little bit, that would be very helpful.
Oh, no problem. I apologize. I believe how do you take notes and prepare the documentation?
So I typically start with a case summary file where I take basically screenshots from material I'm reviewing so I can keep track of where I got what information from. And then I generate an analysis file. And that's basically specific information from the materials I reviewed against, but more condensed. And then I go through an analysis.
And so for your case review file and the information here that would be provided, those photos, for instance, you didn't...
You have to slow down, please.
These photos specifically would be taken at different times, right?
Which photos do you mean?
For instance, what's labeled TRM demonstrating rake position.
So those are not photos. Those are screenshots from a video interview of
And
TRM.
you also included Dr. Hammer's letter, I believe, regarding Ms. Mullis and this case specifically, right?
Yes.
And
Excerpts of it. Yes, excerpts of it.
The analysis and information that goes forward from there, those aren't your pictures or those your paragraphs, right?
So again, continuing on, I contain excerpts from Dr. Hammer's report. Those photos are from autopsy, I think, or from Dr. Thompson's photos. And then some inspection photos of the rake.
Including Dr. Balley's reports, figures, numbers 19, 20, and 21, I believe.
I don't know what Dr. Bowley's figure 19, 20, and 21 are.
I believe they're included in the same section of the paragraph or supplemental discovery that we'd be discussing here. Would it be helpful to see? I believe it's in your binder as well.
Could you just reference the page? I just think.
Oh, no, call
they're
me
not
Sadie.
numbered,
I
but-
straightened that out. There will be
it's
no more
the-
issues with our beloved MK
I see what you're
Land.
saying.
Fifth from
Yeah.
that.
Yes.
Those aren't your figures, correct?
Those are not my figures, but I didn't need them.
Because like you said, you screenshotted the information and included it so you could refer to it later, right?
I screenshotted information. Again, it's the information for me to look back on, so I don't have to go to multiple documents.
And so this document or your file for purposes of the analysis is mostly reflected in footnote 5. Fair?
Well,
where you didn't include your actual specific data, right?
so from my understanding, footnote 5 I put in there because I was going to be deposed. I had a deposition date for this case and it was canceled. So I was willing to have my deposition where I could provide my details over a year ago, which I think the state canceled.
So you haven't included those details specifically?
No,
here in your
because I thought I was going to testify to them.
Thank you, Your Honor. The state submits its objection again. The information is not provided for her own evaluation and by their own, Dr. Ngai's own admission, was left out for purposes of the deposition at hand. And so the state objects in violation of the rules of civil procedure.
However, my
Okay,
report itself.
hold on. Right. I was told that the information was provided to you on May something through a Dropbox link. If you need a chance to check and see if you have it, I will provide you with that opportunity. But as of right now, the representation is being made that the materials were in fact provided. So that's where things stand. Whether or not they came directly from the doctor or not is irrelevant to me if you have them. So do you need a chance to check and see if you received them on that date?
We can certainly check and we can also confirm.
All right. Let's go off the record. Let me know, please, when you've had a chance to do that.
Thank you.
Recess. Thank you.
Sometimes I like to just listen to the side chatter that goes on in the courtroom when they're waiting for the judge to be there. Also, as I've gotten older, now my skip game used to be like on point, 10 out of 10 would recommend, right? Not by me, by other people. As I've gotten older, I don't know what has gone on with my skip game. It is not good at all. And I hesitate to skip because I don't want to miss anything. We don't need that type of negativity in our lives. All right, here we go.
Okay, Mr. Duden, were you able to identify if you had received the materials that were referenced in that footnote?
My belief, Your Honor, is that we have received the materials that have been disclosed and exchanged during discovery, so there's no dispute as to what we received. I think the dispute is to whether or not it's substantively enough for purposes of an expert evaluation or report, as they're required to include their data, impressions, and opinions. We're certainly willing to wait on our objection in order to talk about that evaluation, but what it sounded like when we left off, or at least my understanding, was that based upon a deposition that had never occurred, that information was going to be left out in order to be asked about. That information was going to be able to be requested at that deposition, but was not included within the report itself. So I think more so it's whether or not the data and impressions and opinions that would be included in the report are enough. And certainly, as our objections had been noted earlier, the answer was no. But we do not believe that there's any dispute as to what's been exchanged.
Okay.
So the state withdraws its objection for the purposes of continuing questioning and will raise the objection again should we go outside the scope of what was, believed to be included in the report itself.
Finally.
Okay, we'll continue. Dr. Ngai, I would just remind you that you remain under oath. Ms. Thompson.
Your Honor, I want to proceed. I just want to say that I'm not sure that reflects our position on this issue, but I agree we should move forward. But I'd rather take this up at another time.
Okay.
Understanding I don't accept that representation, I agree that we should proceed.
All right, we will. And I will just question you. I know we did go a little bit late yesterday. in order to finish with the witness, I have no idea what Dr. Ngai's obligations are as far as time. And we maybe can go a few minutes past 4:30 today, but that will be it. So
I want to be candid with the court that while, this is a witness who is moving expeditiously, I do not think I'm going to be done with this witness by 4:30. I just don't see that being the case, Your Honor.
okay.
All right, let me just say this right quick, okay? I don't think that I've ever actually witnessed a ineffective assistance of counsel hearing. So perhaps this is standard protocol. Perhaps this is just standard protocol for Iowa. This is the way that they do things. I'm just going to say this. I feel like this is a tiny bit excessive to prove ineffective assistance of counsel. I think that the defense has made it clear after 5 hours, and some change of testimony between the forensic pathologist that testified for the defense and Dr. Ngai, that there were other things, important testimony, important expert testimony that should have been sought out by the original trial attorneys. I just don't understand why we need to go into it this deep. This is not the actual, this ain't the retrial. I think this is a little excessive, but I'm going to entertain it because that's what we came to do today. So here we go.
In that, right, I didn't expect that you probably would be, and obviously we have cross-examination. I was just concerned about what the doctor's schedule was more than anything. So I wanted to let you know we weren't going to be able to go late today. So.
Understood.
Okay, you may continue.
I think the question that I posed that led to this break was whether, Dr. Ngai, you had an understanding of the relative weights and heights of Ms. Mullis and Mr. Mullis. And I think you provided an answer, but just because that was a few minutes ago, what is your understanding of their relative heights and weights?
My understanding is Ms. Mullis was 163-ish pounds near the time of the incident.
Oh, clicker. I'm so glad you brought this up because I'd forgotten to mention this part. So obviously when there is an ineffective assistance of counsel appeal and there's a hearing, the former attorney gets called. And this is testimony that I'm very, very much looking forward to. So I forgot about this little detail, and I am reinvigorated with excitement to hear all this. All right, here we go.
About 5'1½".
I think you provided an answer, but just because that was a few minutes ago, what is your understanding of their relative heights and weights?
My understanding is Ms. Mullis was 163-ish pounds near the time of the incident, about 5'1½", and Mr. Mullis is about 10.5 inches taller.
There was height and weight for Ms. Mullis. There was information in her medical records and in Dr. Cruz's autopsy report. Is that right?
Yes.
Were those numbers different in terms of her height or weight?
They were consistent.
All right. And the information in her medical records reflected her weight when she was her weight and her height when she was alive.
Yes.
Okay.
Excuse me.
And I think you started to talk about this, but I just want to make sure we're on the same page since we took a break. It was your determination that it was not possible for the hypothesis that the corn rake in this case was swung into Ms. Mullis's body to be true. Is that right?
Yes, based on my investigation, that was the corn rake was not swung into her body.
And how did you reach that determination?
So again, applying the engineering fundamentals, looking at the wound pattern externally and internally, looking at the intrinsic properties and geometry and measurements of the rake, putting them together, understanding that we know that A, B, and C wounds happen first, and their wound trajectories are about horizontal with the long axis of the body. So you match,
Let me stop you right there. What does horizontal to the long axis of the body mean?
like perpendicular. So perpendicular, near perpendicular to the long axis of the body.
Okay, first of all, I think, let me just say this. When she says perpendicular to the long axis of the body, I know she's talking about the long axis being the top of the head to the bottom of the feet. Feet. Okay, Jen, I'm leaving that in. I'm not even going to correct myself. To the bottom of the feet. I said it. I'm standing on it. I said it. Said what I said. However, what I would submit at this point, if either one of you defense attorneys are listening or anybody at that table, Todd Mullis aside, because I don't think he has access to the YouTubes, I'm going to tell you right now, I've sat through the entire trial, the original trial, and now I'm watching the bench trial, the hearing. And I would suggest, defense table, that should you be granted another trial, I would prep this witness to explain things in a way that the jury can understand, because this is going to be the first time they're hearing it. I understand it. It took me a while. Of course, they will have pictures and they'll be shown, so that might aid if they had a visual to look at, to reference. That would be helpful. But some of these concepts are kind of obscure and a little hard to understand. So I think she needs to use a little bit more lay people terms. Use the correct terms and then explain what those terms are. That would be my suggestion. And the fact that there is geometry involved in this at all, and I understood what was going on, is a miracle. I failed geometry the second semester. So there you go. Was not good at geometry. I did take geometry in summer school, second semester of geometry in summer school. And I'm going to be real honest here. The only reason that I passed in summer school is because the teacher let us grade we had to, how the teachers let you grade your own papers where you pass it to the person behind you. Well, the person behind me was my friend. So she would fix the work and make me have the correct answer. There you go.
That's the wound paths for A, B, C, and D. So if you match up the tines, which have a very fixed position in geometry, now I have a relative position of the rake handle has to be essentially along the long axis of her body. The rake handle is along her body. Essentially, like her buttocks would be contacting the handle upon entry for A, B, and C to occur. So then, understanding that, you look at the swing options. Aside from the multiple swing option, let's look at the first swing option. And a swinging of the rake, overhead swinging of the rake, would generate much steeper angles of wound trajectory and did not match the physical evidence.
I want to show you
See, now why not just leave it there? Listen, I appreciate the thoroughness that the defense is doing, but wouldn't this energy be best saved for a retrial? I feel like this might be a mistaken strategy for the defense. I feel like all of this testimony, the in-depth nature of this testimony is a little too much. And I feel like the defense table would benefit from listening to Kenny Rogers, the gambler. You got to know when to hold them, know when to fold them, know when to walk away, know when to run. I feel like you're showing your hand, just scotch. pull back, just a little bit. I don't think that all this is necessary. I think that you've proven that had the original trial attorneys not gone with agreeing that it's a murder and instead investigated it the way the defendant wanted it investigated, which was as an accident, then it is possible that the results of the trial would have been different. I think that you've demonstrated that. I mean, I don't think we need 11 billion hours from of testimony. I think we got it.
Are we in E? I'm going to show you a demonstrative that we've identified as figure E. Let me just tell the state what this is.
Sarah says, hold on, let me just pause this because we're almost to the end. Sarah says, geometry is the math I didn't have issues understanding. Was algebra the math you had issues understanding? See, algebra, super easy for me. Totally could get it. No problemo. But geometry, no. Geometry to me is like describing what the color red tastes like. I'll say this, Clicker. Clicker says, I agree with you, Jen, but does the court agree with you? And what is necessary to prove the case in court to grant a new trial? Like I said, the ineffective assistance of counsel appeal is a really, really hard appeal to mount, and it's very rarely successful. And that's true. I mean, I've seen some cases where it's blatant. It's not like, I mean, we're talking about like letting the state interview your client without you being present. That type of blatant situation occurring, or like I spoke about earlier today with Jesse Miss Kelly, by the state's own rules, his attorney Dan Stidham would not have been qualified to represent Jesse. So, I mean, those are blatant, and yet those appeals were not successful. I do think, judging by the, I think at this point in the testimony, right, with this specific witness, I entertained the forensic pathologist longer because at issue is it isn't the issue of, did Dr. Cruz document the injuries correctly? That's not the issue. The issue is her interpretation and analysis of those wounds, and thus her conclusion. And I do think it was very important for the defense to elicit that testimony respective to her. She had, how did she say it? I was certain this was a homicide, but I was open to information and also what the internal examination of the autopsy ultimately revealed. Those are two opposing things. You can't be certain and open at the same time. So that was important testimony to get in. But as far as this witness goes, I think, even for the court, that at this point in the testimony where she has explained how she reached her conclusions, why what materials she used to factor in, and why the conclusions are the conclusions that they are. I think I think it's enough for the court, honestly. I don't know that more testimony in this direction from this witness. I don't know what it is this specific judge is going to need to move her. That would be so difficult for anybody to say, because I don't think it's the amount of evidence necessarily. It's not quantity, it's quality of evidence. And quality of evidence is subjective. For example, the weight one would give to different types of evidence, let's say the Google searches. Person A might give a lot of weight to those Google searches, while person B might give very little weight to those Google searches. So it's so subjective. I don't know what would be enough for this judge, quite frankly. Also, that this is just fantastic observation by Rachel. Rachel says he's the only person who looks better after prison. Yes, it's so odd. I've never seen this happen before. And also with this, Sarah says, it would have gone over better if she said she had a working diagnosis of homicide rather than being certain up front. Yes, that was very poor words, and the state did not do a very good job of walking that back at all. That, to me, seems like something that absolutely would stick in a judge's mind. I think that would be given quite a bit of weight, actually, that testimony. It's important. All right, here we go.
Would looking at some demonstrative exhibits assist you in your testimony in describing how you considered the hypothesis of whether Mr. Mullis swung this rake into Ms. Mullis's body?
Yes, how I can demonstrate how I analyzed it, yes.
Okay. You're looking at I think there should be a figure on the screen in front of you, which is we've identified as figure E. Would using figure E help you illustrate your testimony?
Yes.
All right, and can you explain how you determined that swinging an overhead swing would not have, is not a hypothesis that works in terms of how Ms. Mullis received these injuries?
Yes, so what this entails is the figure that demonstrates the wound trajectories for all A to F wounds, and that A, B, C, and D are essentially, like we talked about, perpendicular to the long axis of the body. In an overhead swing, based on the properties of the rake, when you try to swing it into a person, you're creating much steeper angles. So therefore, the type and direction of forces that are necessary to cause Ms. Mullis's diagnosed wound pattern isn't generated from the swing.
So there are different angles at which, depending on the distance of two people, in terms of where they're standing vis-a-vis each other, there's different angles that could be generated by an overhead swing depending on the distance between the two people. Is that right?
So if you want to generate the maximum speed, you mean, then you have to be farther apart?
Well, my question is just that if, for instance, if in this situation, in this scenario where you're assuming people of the relative heights of Ms. Mullis and Mr. Mullis, if you're considering a hypothesis of whether someone standing behind Ms. Mullis and swinging the rake overhead, how that would contact Ms. Mullis's back.
Yes.
Depending on the distance between the two people, that angle might be different. Is that right? The angle at which the rake hit Ms. Mullis's back.
So you want the rake tines to hit. So that you're not talking about the other parts of the rake.
Let me ask you a better question.
Okay.
Would the distance between two people in a hypothetical where a person is standing and then a person is standing behind them swinging a rake overhead, would the distance between the two people impact the angle at which the rake tines hit their back?
Well, if you have them closer, the rake tines might not even hit their back at all.
And why is that?
Because of the, again, intrinsic properties of the rake. It has a specific length, has a specific entry point if you want the tines to be in there. So they have to be positioned and oriented in such a way that the rake tines enter her body while she's hyperextended.
And is there, but could you envision in testing this hypothesis any sort of position where a person could have been standing behind Ms. Mullis and swinging the rake overhead where the specific injuries with the specific pattern and trajectory that Ms. Mullis's injuries had could have resulted?
No. We tested standing upright, various angles of bending over, lying flat on the ground. The way the rake tine is built and her nature of her injuries, and knowing that she has to be hyperextended at the time the tines enter to cause A, B, and C, the angles don't match. The position and orientation doesn't match. Therefore, the mechanisms, the type and direction of forces necessary to cause those specific diagnosed wounds don't match.
I'm going to show you figure F. Let me have you take the demonstrative away and let me ask you a different question. I mean, you've talked about the rake being the hypothetical that the rake was swung overhead. There's other ways that a rake could be swung into a person's back. Is that right?
Yes.
I mean, another way would be through more of a baseball swing.
Yes, a
swing
lateral
sideways.
swing. Yes, a sideways swing.
A lateral swing. Did you consider that hypothesis as well?
Yes.
And could you prove or disprove that hypothesis?
Yes.
Which did you do?
Disproved it.
And why is that?
Again, based on the intrinsic properties of the rake and the injury pattern. If you're going to swing it sideways into the body, you would have a more vertical oriented wound pattern. That's in line. That's not what she has. Additionally, the wound paths through her body wouldn't match. So again, the mechanism of injury necessary to cause her diagnosed wound paths aren't generated with a lateral swing.
You talked earlier about your understanding in this case based on the medical diagnoses that Ms. Mullis's back would have been hyperextended at the time that she experienced these wounds.
So biomechanically, that is true as well.
Right, and would the fact that her back was hyperextended and to hyperextend her back that her arm, at least her right arm, would have had to have been back, did that impact your analysis as to whether any kind of swinging could have caused these injuries?
I mean, the arm could get in the way again as well. So if you're talking about position and orientation, in order to get that A wound, which is on the side of the chest, with your arm, if you're trying to swing it, the arm is in the way, essentially.
What about
Okay. I think, and this is something I hope the defense table is listening to, in order, I think, to adequately convey the testimony for people to understand it, I think what needs to be said here is if it's this hyperextension, most people, as I understand this testimony, would not be entering a barn hyperextended, meaning they wouldn't be entering that barn with their shoulders placed back, particularly if they were attempting to open a door wider. In fact, it would be opposite, right? Your hands would be on arms would be extended out in front and you would be pushing. So I don't think, I think what she's trying to convey here is that the reason they believed that it was a fall based on the wounds and the trajectory and the size and the shape and all the measurements and the geometry and physics of it all, respective to the corn rake, is that this hyperextension came as a reaction to something first, and that something was not being hit with the rake. Does that make sense? Am I explaining that adequately? Like, you might hyperextend if you fell, if you were falling, right? Because she was already, what the testimony sounds like to me is that at the time the tines initially entered her body, Amy Mullis was already hyperextended. And that is just do what she's saying. Be twisted to the side and push your chest out and your shoulders back. No, Tony, I'm thinking the hog barn is something completely separate. It's, to quote Aunt Brenda, it's humongous, baby. It's big. It's the size of 2 football fields in length. I'm talking about the size of that red shed. The size of the red shed internally, with all of the things that were in it, is the shed itself is a decent size. It's just the space inside of the shed that's available for swinging or walking is very narrow. Yes, thank you, Sarah. That is what I'm trying to say. Hyperextension as a reaction of loss of balance or grabbing door frame while tripping. Yes. No, babe. I get it. Now I understand what you're saying. Okay. You meant the shed. So let me go back. Yes, I'm thinking that I am thinking of the size and the area, but okay. When you're entering a space that's narrow and you have to squeeze inside, most people would naturally, if they would roll their shoulders in and press their arms forward, not the other way, not backwards. Does that make sense? They would, when you're trying to squeeze into an area, most people go forward because that's the motion. They're trying to get in, not out. Now, if she were trying to get out, I could see potentially, but then if she were hyperextended at the time, signs of the corn rake hit her, then Todd would have had to have been inside that shed with her, behind her. Am I making sense now? Because this is incredibly technical, and it's definitely not jury-friendly testimony. And also, one thing that the jury, if there is a new trial that's granted, if they decide that Todd should get that the conviction should be vacated, and he in fact does get a new trial, and the state decides to charge him again with first-degree murder, the jury most likely, because she's being shown demonstratives, etc. My thought would be that the jury would also be seeing those at the same time. So perhaps because I'm not seeing what she's seeing, it makes the testimony a little bit more difficult to envision, and the jury would likely have that. But I still think there needs to be I still think that there needs to be some layman's terms interjected into the testimony so that the jury can understand what she's talking about. Hope I'm making sense.
Hypothetical where instead of, in a hypothetical, somebody of Mr. Mullis's size standing behind Ms. Mullis, they're facing each other at the time in this hypothetical that the rake is swung. Did you consider that hypothetical?
Yes.
And what was your conclusion about the possibility of that hypothetical?
It was that hypothesis is disproven.
And why is that?
Because again of the wound paths and the rake, if you swing overhead, you're going to have upward trajectories. And then we already know that ENF can't be generated first because it's essentially in the middle of their back. You can't have two tines entering in the middle of her back without a third tine contacting. And we only have two wounds that are upward trajectories.
If someone had swung the rake into Ms. Mullis into wounds E and F, would there have to be other wounds in that same trajectory?
You'd have again, a third tine sometime would have to contact it because of the location of the wounds and the spacing between the tines.
So I think we've shown you well, I want to ask you this. I mean, is it possible for somebody to have swung the rake into any of these wounds, wounds A through F, and had one tine make contact with her body, and all of the other tines missing her body?
Yes, Violet. Violet says, I need a recreation or a picture. Agreed. I do think we need, I think the jury would definitely need like a recreation. I don't know, because I'm not an attorney, obviously, but I'm not sure how. I know that recreations have been admissible in trials in the past, but I don't know what the criteria is for those to be admissible. And I would imagine that in this case, because there are so many unknowns, for example, there is the only documentation of the position of the corn rake is after the fact, after the rake was removed from Amy Mullis's body by Todd Mullis. It was left in because he departed the shed with Amy and put her in in his vehicle. So it was moved and I don't know how. There's just too many variables, I think. So I'm wondering if that would be allowed.
So again, we talked about how the wounds are essentially in the middle of her back. The nature and diagnosis of her wounds and the intrinsic properties of the rake, you cannot insert one tine at a time.
Does the condition of Ms. Mullis's coat that she was wearing at the time she came to the hospital, does that factor into your opinion that the rake could not have been swung into Ms. Mullis?
It supports it.
How's that?
Well, again, she has 6 holes in her body, and there's 4 tines in the rake, and there's less holes in the coat than there are in the body. So if you swing it, even though we've proven that the trajectory doesn't match with any kind of swinging that we've talked about, if you take that rake out and re-swing it, you still have less holes in the coat than you do in the body, so that doesn't matter. So that's, again, further support that a swinging incident did not cause these injuries.
Given your training and expertise in biomechanical engineering and the investigation that you conducted in this case, Dr. Ngai, can you think of any position that Ms. Mullis and a hypothetical assailant of Mr. Mullis's height could be in vis-a-vis each other? Any position that they could be in relative to each other where, from an engineering perspective, it would be possible for someone to cause this wound pattern in Ms. Mullis's back from swinging this corn rake into her?
So I analyzed the information that's available. There's no, information that there's a trapeze available. I can't analyze every single 1,000,010, possibilities. Those are all unlikely. I have to take into consideration the evidence in the case. And engineering analyses, like we talked about, don't take 2 seconds to do, right? So my analyses are based on the information that's provided and the scenarios that are provided. But from my analysis of the case, given what I have, there was not an alternative scenario that fit the physical evidence and the science.
Did you consider the hypothesis that someone pushed Ms. Mullis down on the rake?
Yes.
And did you determine whether or not that hypothesis was possible?
I considered it, but I considered it.
And could you prove or disprove that hypothesis in your consideration?
I disproved it.
And why is that?
So when you push someone, you are imparting horizontal velocity as well as rotational acceleration to their body. So when you push someone, they're going to essentially rotate, kind of flip. And if this rake we talked about is top heavy. So if you're falling on the rake with horizontal and rotational acceleration of your body with your upper body and you hit the rake tips, you're going to flip this rake. And if you flip the rake, then you don't have the rake tines pointing up in the manner to cause the injuries.
So Margie asks, what is your opinion, Bendy? Is that guy guilty of killing his wife or no? Just your honest opinion. I don't know. Legally, if I were on the jury, I would have had reasonable doubt during the first trial, the original trial. All of this, none of this testimony, because I remember doing talking about it, and I had reasonable doubt. Actually, that's not true. I can't remember exactly how I felt or what I said at the end of that trial to be. I know that this case still interested me, and I did have questions. But as I sit here today talking about this, if I'd been on that jury, I would have had reasonable doubt. And that's before I even heard any of this testimony. I just don't remember how I left it, whether I said that or not in my life. I don't remember. It's been too long. But that's very different than an actual innocence claim. I'm not there yet. What I would need to hear from, first of all, hearing evidence is very different than seeing evidence. And I need to see what she's looking at so that I can, understand what she's talking about, this witness. Also the same with the forensic pathologist that testified for the defense. And I would need to hear potentially from the state with this having a similar witness from themselves testifying, meaning another biomedical or a biomechanical engineer. I need to hear pro and con arguments, if that makes sense. I'm just not there yet. I'm still really, really on the fence.
And when you talk about it generating horizontal force, if someone is standing in front of me and shoves me, hypothetically, 2 hands into my 2 shoulders, that horizontal force, where is that going to send my body?
It's going to send you backwards and rotate because a person standing upright, their center of mass is about 55% of their standing height, so about navel. So we're already slightly top heavy, generally speaking. So now if you push someone above their center of mass, now you're going to move them backwards and rotate them. So basically you're going to flip them with their feet coming up, in a sense.
Your Honor, I think I probably have maybe another 20, 25 minutes. I think this might be a good time to stop for the day, and we will endeavor tomorrow to finish promptly.
Sure. No, that's fine. Thank you for letting me know this is a good time for a break.
Okay, so I'd like to hear the rest of this testimony. So let me go over to the YouTubes and just check really quickly how much longer it is on day 3. And if it's not too long, I will do just this part of day 3. Just give me a second. I'm scrubbing through because they start with an officer on day 3. Oh, she's at the end of day 3. Hold on a sec. Oh, let's see. Give me a second. I'm trying to do math. We all know that's a issue for you girls, especially when it comes to time. There's like another 2 hours more, and I don't have another 2 hours this morning, which I get it. They jumps. I'm glad that I went to look. So this is what we'll do. I'm going to end it for today. And what we'll do is rather than when we start day 3, rather than start with the first witness called on day 3, we're going to finish Dr. Ngai's testimony so that we have some continuity, because I need that for my own brain. And then we'll go back to the beginning of the day and watch them last. Does that work for everybody? I hope so. I um I I'm really still on the fence with between, uh an actual guilt and an actual innocence claim. I really am. I still I will say that jealousy, for example, over a spouse having an affair. I mean, it's one of the like oldest motives for murder um, ever. Before there was like actual currency and stuff, I think jealousy, like cheating, what that kind of thing is probably, it's the oldest, followed by maybe money for motives for murdering somebody. But, oh, perfect. Clicker. Thank you. I will, we'll figure that out when we get to his, testimony. Thank you for letting me know. But yeah, I just feel like at the end of the day, what I would like to see at this point, because there are so many questions, just for me personally, right? Um, I think it would be beneficial for a retrial, frankly. I cannot imagine a scenario where if the judge decides to vacate his conviction and give him a new trial, I don't think that I can't at this point imagine a scenario where the state does not retry Todd Mullis. Is it possible that they retry him under different charges? It's lesser charges, manslaughter maybe, or second degree murder, something else. I'm not sure. Everything is, most things are possible, probable. I think it's more probable than not that the state is going to retry him. What that looks like, I don't know, but at the end of the day, I would like to at this point, I would like to see a retrial. However, I also am very, very interested in hearing from Mr. Mullis's original trial attorney. I think that um, I think hearing him and what his thought process was as far as the way to present his defense, and um, did Mr. Mullis in fact ask for the accident theory to be investigated and presented? All of those things, like, I'm interested in all of that. And so that's me. That's where I'm at today. And like, as I said, my opinion is always subject to change because I'm not certain of anything. I am actually open, right? I'm not saying, oh, I'm certain this needs to happen, but I'm open to other thoughts and ideas. If you're open, then you're not certain. Anyway, that's right. Exactly. Clicker thought process, lack thereof. I want to hear what he has to say. I just do. So, I will be back tomorrow. I think actually we're going to start earlier tomorrow. I think we should start at 8 a.m. Central Standard Time, 9 a.m. Eastern. Because I think I think we have a long day tomorrow, and I want to make sure we get it all in. So that's what the plan is. But I want to thank you guys all for being here today, and I've so much enjoyed our chat. Um, hearing you guys' thoughts and ideas and theories, and I appreciate it because it makes me think. Um, Ooh, I want to hear about from Todd's sister too. All right. So I'm going to leave it here now for today. Thank you guys again for being here. If you have not done so already, would you please give your girl a thumbs up? I would appreciate it very, very much. And I'll talk to y'all later. Bye.